Good afternoon, everyone. I'm Amrita, Research Associate at Institute for Governance, Policies and Politics. IGPP brings to you an insightful discussion on the Telecommunications Act 2023. Assented by the President in December 2023, the Act aims to replace the regulatory framework established centuries ago in order to modernize and consolidate the regulatory framework on telecommunications and to boost the sector's growth. This discussion will help shed light on the significant highlights of the Act. What are the issues or challenges that it presents? And what is the way forward? Before we begin the discussion, I would like to introduce all the panelists. Mr. Deepak Maheshwari is Senior Visiting Fellow at Indian Council for Research on International Economic Relations. He is a policy consultant, researcher, and archivist with a keen interest in its interplay with technological innovation and socio-economic development. Ms. Amrita Choudhury is the director of CCAOI. Her work focuses on a wide range of issues, which include empowerment of the public internet access providers, assisting internet users and non-users, and promoting internet awareness through digital literacy and vernacular internet. Ms. Namrata Maheshwari is Asia Pacific Policy Counsel at Access Now. She also works on encryption policy, privacy, and surveillance in a global context. Mr. Sumeysh Srivastava is Senior Manager of Public Policy at the Quantum Hub. His research interests are primarily in areas of access to technology, information, and rights in the digital space. He writes on issues that look at the intersection between technology, law, society, and access for both academic and non-academic platforms. This session will be moderated by Dr. Manish Tiwari, Director, Institute for Governance, Policies and Politics. I now hand over the discussion to you, sir. Thank you.
Thank you so much, Amrita, and thank you all the panelists to join us at IGPP for this discussion. We are largely trying to discuss about the latest Telecommunications Act 2023, and we would like to focus on two particular aspects. One is about like how this law, like what are the kind of things it is changing and how it is going to impact the kind of developments in the technology sector, particularly in telecommunications and OTT and others also, whether it touches them or not. And second is how in today's world, when we are talking about, a lot of things, including AI, how these things would, like this act would impact the whole development of AI, because somehow we are experiencing AI in everyday life through our phones, and phone to us is coming through the telecom companies. Now this distinction is a little, I would say, cumbersome to kind of make the distinction and where do we go. So if I'm facing an issue with a AI related problem, or there is a kind of something which happens to me in terms of a fraud or something else, then who do I go to? These are kind of questions which general public faces, and more than them, also because this discussion is also targeted at policymakers, so they are also kind of at times a little I would say confused about the whole thing, like where do we take it? And I'm not talking about the people who are kind of expert policymakers, with the which is very few in number. But if we talk about the MLAs and MPs, all other number except a few, very little percentage. So how do we take it to them? That is what we would kind of begin with. So the Telecommunication Act of 2023 has replaced many long-standing laws, and which are kind of archaic in nature, like the Telegraph Act 1885 and the Wireless Telegraphy Act 1933, the Telegraph's Wires Unlawful Possession Act 1950. So we are replacing things from the age-old system. Deepak ji, I would like to begin with you here. And let us know, and our audience know, what are the kind of significant changes we see in this bill? What would be the kind of departure from?
Thanks, Manish. So first of all, I would say that just because a law is old does not automatically make it archaic. So for example, even today, we have a lot of laws that continue to sort of apply, which are even older than the Telegraph Act 1885. Okay, so we have the Contract Act, for example, 1872. Okay, of course, there's this 3 new sets of laws related to criminal justice. They have been passed by the Parliament, and now let's see how they'll get implemented. But even there, if you see, the Contract Act is not just 1872; it's also the Evidence Act, which is also 1872. Okay, IPC is 1860. So that's one aspect. But anyway, let's come to this particular aspect of the Telecommunications Act now. So yes, it does replace the 3 prior legislations, the Telegraph Act 1885, then the Wireless Telegraphy Act, and of course the unlawful possession of telegraph, which is another legislation. And people like you and me may still remember that it was just about less than 41 years back, just before the Asiad Games in 1982, when we got rid of the licenses for the radios and TV sets at home. So for some of the youngsters here and even in the audience, it might be something very novel to sort of think about. We used to go every year in December to post office to pay a certain license fee by way of a stamp. And so there used to be like a small booklet, like a passport for every transistor set, every TV set those days. Okay, so it was only in 1982 that thing got done away with, and those were being licensed under the unlawful possession of the telecom equipment, that particular act. Anyway, so now that we have this particular legislation, I think there are 3 fundamental changes that has happened now. One, instead of having 3 legislation, of course, now we have 1, but we continue to have a TRA Act, which is separate even today. And there are other laws in the realm of, let's say, IT. So there's the Information Technology Act, and of course there's now talk about the Digital India Act, and of course we do have the Digital Personal Data Protection Act, DPDPA, which also got passed last year. The second aspect is to do in terms of what the core differences now. So I would say so if you see the definition of the word telegraph in the 1885 Act, it was so fantastic and so broad that when India introduced many new telecom service licenses, and this, by the way, did not happen in the 21st century. This happened in the last decade of the 20th century, in the 90s. So we introduced cellular, paging, internet, VSAT, public mobile radio trunking service, audio text, video text. And by the way, there used to be a license even for email those days in early 90s. Okay. All these licenses were granted under the Indian Telegraph Act 1885 using the same definition. The 5G services that were launched 1.5 years back under the same license. You have 6G, 10G, NG, anything, it can all be done using the same license under that definition. So that definition of the word telegraph itself was quite comprehensive in that sense. And that definition, although the words have changed a little bit and there are few additions here and there, but it's not significantly changed even in the new dispensation. One thing which has significantly changed is the adjudication process, and we'll come to that a bit later in terms of how things will happen. And the other big change that I see now is in terms of the Universal Service Obligation Fund, which is not very old as such. It's only about 2 decades old overall, but there's a significant change in terms of its scope of the things that it can be used for. So let me stop there for the time being, and we'll come back to some of these issues later.
Amrita ji, I would like to come to you. Like, you have been working around the public internet access providers and for the cause of internet awareness among the people. What do you think, in your perspective, how would it help the common people better if we talk about like the changes in the law? Would it make any impact, or does it only impact the industry or the kind of service providers?
So let me begin with that the telecom providers are providing a service which you and I end users are using. So whatever regulations come in, it affects us. Say, for example, today there is more ownership is given to a user. For example, that there are some do's and don'ts. But in a country where people are not aware, the lack of awareness, digital literacy, etc., is an issue. Will a person sitting in remote area know what his rights and duties are? Especially when they are coming online, they do not have digital literacy. So are they sure as to what they're posting is right, what they're not posting is right? As in, it is good to have a regulation which is forward looking, a bit vague, but too much of vagueness also is an issue. For example, we at this point of time, the bill is very broad. We are still awaiting the rules to see how it goes. For example, if there is a shutdown somewhere, how is the shutdown going to be implemented? What are the accountabilities? What are the checks and balances in place? We are not aware of it. Or for example, for national security, etc., if certain things are seized from some person, who looks at it? Is there going to be more censorship? Is there just one kind of information would be allowed to flow? So those are certain concerns which are coming. It's not that I feel the government is intending for it, but somehow it looks a bit like that. And, if you look at the definition, it is pretty broad. I understand they want to make it broad, so it's more forward looking, but sometimes broadness has a concern. If you look at the bill, for example, it seems OTT is included, but the minister has clarified it's not there, but it's not written in the bill. So are we going to see it in the bills? What if it is changed tomorrow? Of course, things may change, but those are certain, I would say, concerns which are there in people's mind. And if there is more censorship, then people would lose more trust on the internet, because internet today has become a lifeline. And initially you were talking about AI. Now, AI is a technology. What does AI do? It actually processes your and my data in particular ways based upon the algorithms, and then it gives us the information, the question of deepfakes, etc., which is coming. But the question is, are we aware of, as users, how many people are aware of what they can post, what they cannot post? Many times they post sincerely certain things that it is correct, but it is fake. For example, messages about, kidneys being offered, etc. People are genuinely posting it, but that information is incorrect. So that media literacy, etc., is not there. Expecting a user to be accountable for everything is difficult. And the other thing is, anonymity. Sometimes you need anonymity. There are people who don't want to be exposed. Now, not all anonymity is bad. I understand that, there are bad actors who use it in a different way, but sometimes we have to give people some amount of anonymity online. Also, if, encryption is broken to some extent, you and I, for example, if we are having a personal conversation and I always have a doubt that someone can look at it, it is concerning. My rights, etc., also can be hampered in that way. So I think we need to balance freedom of speech. National security is absolutely important, but we need to see the balance, how we can do, and for that we need the checks and balances. So I think it's good to make people accountable, but are people aware that they need to be accountable and how they can be accountable? That's the question. So I'll leave it at this.
Sumeysh, I want to come to you from the rights perspective. Like, when Namrata is talking about it should not be left on the owner should not be on the user. But what about the rights? Like, the rights which we want in terms of our privacy, in terms of, like, even a simple thing like do not disturb. How does this whole change in the act, does it help us there?
So thanks for this question. So I would echo one thing that Amrita ji had mentioned, where in terms of a lot of the clarity on the operational details of how this act will affect users or the industry is something that will become clearer once the rules also come out. Because one of the things that you might notice in the act itself is that while a lot of legislation has been delegated, there is not a clear framework given. as to what will be the principles, how will this be delegated. Now, if I talk about user protection or user rights from a specific perspective, we can see that there are certain things mentioned. For example, there's a mention of the DND register. Now, the thing is, DND is something that TRAI has already been implementing, and now due to the act, we have a legal framework for it. But I think a lot of it will depend on the implementation. I think this organization called Local Circles had done a survey last year, where they had shown that a lot of people, that the amount of spam and scam calls that people are getting are increasing exponentially, and this is leading to a lot of financial scams as well. But one interesting point in that report was that 92% of the people who were receiving these calls were already registered on the DND portal. So the point is that a lot of the things which have been included already exist. It's something that TRAI has already been working on, and actually in the past couple of years, both TRAI and DOT have become a lot more active on this. So I would say in terms of protecting users, it's something that will depend on implementation, whether this act will lead to a change in how DND is being implemented or enforced. The other perspective that I would also look at from a user perspective is when you look at things like interception, or when you look at something like, for example, biometric verification is also something which is being talked about. These have to be done within a certain framework, because every time you're doing something like this, you are infringing on the users, compromising the user's fundamental right. Now, that framework is not very clear in the Act itself. They do mention grounds such as public safety, national security, but these are very broad grounds which can be interpreted broadly. Very interestingly, in the parliament, when I was hearing the debate about this, the Honorable Minister, Mr. Ashwini Vaishnav, he talked about how interception will be implemented as per the guidelines given in the PUCL case, which was a phone tapping case in 1997. But interestingly, if you go to the case itself, there was the question of whether interception should be done under judicial oversight instead of administrative oversight. And the court had said that this is something we cannot intervene in because it's not mentioned in the framework of the Act. So we are seeing the same situation here, where this was an opportunity to sort of hard-code these frameworks and these principles in the Act itself. And then these would guide how interception is implemented. These can guide how you're authenticating users. So I would say that once the rules come out, then it will be easier to give a definite opinion. But yes, the fact that a lot of things like DND and all have been given a legislative backing, I would see that as a minor positive for users, for you and me.
Thank you, Sumeysh. What you had mentioned about biometric, I want to come to you, Namrata. Like there is a lot of debate around the verifiable biometric-based identification to reduce spam calls and everything else. This whole identification method has been introduced for consumer protection, as the bill states. But do you think, does it really, it's like entailing your privacy, like invading it, or it's more transparency? How do you see it from largely more of a legal perspective as such?
So I think as far as verifiable biometric ID is concerned, there is the question of how it seems in theory versus how it might work out in practice. And we are coming at this from some sort of experience, right? We're making great strides in our digital public infrastructure journey through the India stack with its layers of digital ID, through Aadhaar, and then the other stacks layers, including digital payment and data exchange, right? So there is already a very strong kind of tech scaffolding around Aadhaar. But equally, we're seeing privacy incursions play out, where a lot of these things were rolled out as actually a mode of inclusion, but the way it has worked out is that it has also facilitated exclusion, right? One example of that is a lot of welfare schemes are linked to Aadhaar, but there are several studies around how many people are excluded from those benefits because you need Aadhaar, you need to be able to present your biometric ID to be able to avail of those benefits. But that level of last mile infrastructure access is not yet available in India. It is happening, but the question of whether Aadhaar in itself, when we started from a point of it not being made mandatory, where it was kind of adjudicated upon by the Supreme Court to say that it should not be made mandatory, I think these steps end up not just a soft pressure, they end up making it mandatory in a way that is not aligned with the kind of necessity, proportionality, data minimization, all these principles that need to accompany any strides that we make on digital ID or kind of making mandatory in any way. The other thing is also, when we talk about Aadhaar, we usually talk about what the impact of state access on this could be, or how much data, sensitive data, does the state hold, how much can we trust the state with it, what are the uses, etc. Right? What the Telecom Act does by making this a mandate for service providers is that all of this data now becomes available to the private sector as well, which again is a whole new animal when we look at the impact on rights and the use cases. So I do think the intention is good, but whether even if it's inadvertent, the impact is going to be that we are moving far faster towards kind of those restrictions on privacy, which is a fundamental right, before we incorporate those safeguards that we have made progress on, right, in the past through the Supreme Court's jurisprudence and other things. So I think the intention is good, but we really do need to be very careful, one, about not making it mandatory, two, as Amrita ji said, right, there is a level of anonymity that is extremely important online. When we do this, we pretty much rule that out. And that in itself, to me, is neither necessary nor proportionate and might not even stand the test of law. So to that extent, I do think that needs a lot of reworking, perhaps through the rules or through amendments, but it would need to be revisited.
Deepak ji, I just want to come back to you on this, what Namrata is talking about. The Act provides the government with more powers of interception and search, under which messages or a class of messages between two or more persons can be intercepted, monitored, or blocked on certain grounds. And they can forfeit your instruments and all kind of things. Now, from the 3 point of view: public safety, national security, and lawful interception. In this whole thing, where does our privacy goes off?
So this is a very, I'll say, challenging thing in terms of the way these norms have come. So now the moment you make biometric verifiability as a mandate for KYC, so earlier, yes, KYC was there, but now you're saying biometrically verifiable KYC, and it may not be necessary only for, let's say, the telecom service providers. That's the type of connection where you might give it once, but it might be even necessary for one to subscribe to any of the OTT services, just in case they do bring in here. Although I hope that it does not happen, but just in case that happens, that will be quite a challenge. The third element there is something else, which is about self-incrimination. For example, a lot of people are using today facial ID for unlocking the phone because it becomes easy. You don't have to remember your pattern or a passcode or anything like that. But then once the law enforcement has your device, they don't even have to ask you for your password. All that they have to do is just literally show the device in your face and it will unlock. Okay. So what happened in the US in the Apple case a few years back might play out now in a totally different manner here. And this is something which might go against the fundamental right that we have in the Constitution, which is a right against self-incrimination. Okay. And currently we do not see any safeguard with respect to that type of possibility in the law. I mean, it could have been sort of carved out that, yes, while biometric verifiability is necessary for the KYC, it cannot be used for those type of situations. So there could have been, so I think there was an opportunity here. There was also, of course, an opportunity in these three legislation, the trinity of legislation in terms of criminal justice. Again, even there, we did not find anything like this. So even if that is not the intent, such a casualty cannot be ruled out. The second thing which I wanted to mention at this point of time is related to what you started with. You said that, yes, we are talking about AI, etc. Now, any of the biometric sort of a match uses AI. So, for example, a password is a 100% match, or so it's a binary thing. Either it matches or it does not match. Whereas when you're doing a biometric, whether it's a retina scan or whether you do through veins or you do through a fingerprint, there's always a percentage. Okay. So it's not 100% match always that way. And in those situations, obviously, you're using AI in some manner, at least at the back end, and also in the front end as far as devices are concerned. And when you're looking at right now, of course, we are talking about the Telecommunications Act, but let's also not forget that just some time back, the government also released a draft broadcast service regulation bill also. Okay. And there's a talk that, yes, OTT might be there. Okay. So again, not very clear at this point of time, but it must be at one of these places and hopefully not at both the places. That will be even bigger challenges. But if we go back 22 years, in 2001, the government of India had introduced a convergence communications bill after a lot of consultation. It was drafted by Mr. Fali Nariman and others. It was introduced in the parliament. It was referred to the standing committee, which was headed at that time by Mr. Somnath Chatterjee. They gave their report also. Of course, there were a lot of people who opposed it for different aspects of it, but not the overall concept as such. And so the idea was that telecom as well as broadcasting, both of these should be looked at by a single regulator, by a single, and that regulator at that point of time was also supposed to be the licensor. Currently, the regulator, TRAI, is a regulator both for telecom as well as for broadcasting, but the licensing continues with the respective ministries or department, like the Department of Telecommunications or the Ministry of I&B. And TRA's role as well as licensing is concerned is only recommendatory. But in the CCI, that type of CCI, the Convergence Commission of India, at that time, the way it was envisaged, this was before the other CCI, Competition Commission of India. And the idea was that that will be the regulator for both telecommunications as well as for these things, as well as for some of the services, by the way, including OTT. The way people are talking, of course, the term OTT was not used, but it had sort of come out with 5 different layers of different type of licensing of different structures in at different layers, starting with the physical network, the application services, etc. So there was that attempt. We did not do that, but the fact is that Malaysia already had done it a few years before, and many other countries did. UK did. They merged 5 different regulators into a single one around 2002, 2003. Few other countries have also proceeded further on that. So that was another thing which I just wanted to mention, that we do have a common regulator for telecom as well as for broadcasting, but we continue to have different administrative setup for licensing and policymaking.
So I think I just want to put this question primarily to Amritaji, but whoever wants, we can bring in the whole question of internet shutdowns. And now your phone is not just phone, it's not just a telecom service. It's like, lifeline. You can't move out in a city without Google Maps these days, most of us. Without OTP, you can't access your banks. So it's a very basic thing, starting from like, somebody who is holding a very simple account in a small bank in a village would only access it through an OTP. And if a fraud happens, who gets responsible? That's the major thing. Now, come to internet shutdown. We in the country, as a report came out from your organization, Namrata Access Now, that this whole our country has a maximum number of internet shutdowns. Now, how do we kind of deal with that? Because so every month there is some exam. And whichever state has an exam, they shut down the internet. Now you cannot do anything without it. So where do we go in terms of like, is it something which the telecom should be done? As you are saying, there has to be a convergence. Where do we reach there now in this whole thing?
If we look at it as in, firstly, I think convergence is a bit far from us in terms of regulator, because if we look at TRA as a regulator, they do not have the understanding bandwidth at this point of time to regulate content also, which is very difficult. Though they are regulating broadcast and telecommunication, they're not regulating content of broadcast. So, and that's a different beast all total, which is very difficult and in today's time. Now, coming to shutdowns, it is unfortunate that we are having shutdowns. And if you speak to most law, administrators, etc., in places, they also do not want shutdowns, but they feel that, okay, internet is a pipe, let's close down the tap and the water will not throw. So I think one is the lack of understanding of how to deal with issues without shutting down the internet, because there are other alternative ways to reduce, there are serious issues wherein lives are at threat. And there are examinations where you're just closing it down for something. So, there are critical issues, there are non-critical issues, I would say. And people think this is the easiest way to kind of shut it down, but issues still happen. So I think the lack of awareness or understanding of how to use technology to counter technology content. For example, if there is some miscreants who are spreading information, the police also can spread that information and counter it. So how do you kind of manage that is important. And shutdowns actually is not a solution. Even Internet Society has done a study and seen that there are not only economic, there are other aspects which people, lose. And I could share those reports with you there. So, people, for example, someone far flung in Manipur, maybe looking for a job, is not getting that opportunity. So those are concerns. We are playing with lives, not just the lives in that crisis, but other lives. Nowadays telemedicine, for example, is important, etc. When you can't leave a home and go, the online is the only way you can do. And India is a mobile country. It's not a landline, it's not. So we need to keep those into consideration when we are making laws. And I think the capacity building of law enforcement people or district administrators, etc., as to how to manage technology or what internet does is important. Because if we look at it at times of floods and even during COVID, this particular piece has helped the administrators in spreading information. I think there are certain things which there are issues, but we need to, as I earlier also mentioned, media literacy, etc., is important for it. And obviously, shutdown is not something which is acceptable even to the government. If you speak to them, they would be saying. But I think the alternatives need to be discussed. We all know shutdown is bad, but how do we cope in such kind of situation is, I think, something which needs more deliberation.
Namrata
If I
ji,
could
yeah. I
Yeah.
want you to come on, whatever you want to say, that is one, but also talk about an alternative if you have in mind something of what we can suggest.
Sure. So, Manish, going back to your question, when you said, we can't go anywhere without the internet anymore, that's also literally true in some ways, because there have been examples of this from the internet in Punjab and other places, where the FASTag on our vehicles is now also connected to the internet. So if you're stuck at a toll booth and you need to recharge, but you don't have access to the internet, you are quite literally immobile. So in that sense, it's kind of what Amrita ji said about telemedicine since the pandemic, right? I don't think it has ever been truer how we live our lives now in multiple realms, and a lot of it is online. We read this all the time. Our phones know more about us than our families and friends do, right? Because that's how much we use it. Students use it for education, journalists use it to report, right? The Manipur example, so much of the news could not come out of the state because of the shutdown. Elderly people can use it for healthcare and so on. So I think as far as shutdowns are concerned, the Telecom Act, coming back to the Act, I think what we're seeing in the provisions of the Act, which is essentially a blanket power to suspend services, is at odds to me both with the past and with the future. And when I say that, what I mean is when we look at the past, we have the Anuradha Bhasin judgment of the Supreme Court, which recognizes the right to connectivity as an important component of our fundamental rights. And it also lays down certain guidelines. It says that shutdowns cannot be indefinite and so on. we have the Parliamentary Standing Committee on IT's reports where they made recommendations to the government saying, look, shutdowns have this impact on rights, maintain a central database of all the orders or publish all those orders, what is the exact authority under which they are being imposed. And just a few months later, they published another report expressing disappointment at no action having been taken on these recommendations. And finally, of course, we have the telegraph rules also, which are not great, but they still do have some minimal safeguards, right? There is a provision for a review committee. Now, how much it sits, how effective it is a separate discussion. What I'm trying to get at is that we have all this body of kind of baby steps that we've taken towards progress, but the Telecom Act does not incorporate any of those things. If anything, it kind of makes the power to impose shutdowns even more blanket without safeguards. And when I say that it is at odds with the present and the future, what I mean is, again, our Digital India vision, right? We are exporting our DPI model to a lot of countries where our UPI system is worth emulating by so many. We are relying on apps and digital platforms for a lot of essential services. At the same time, if we are a country where millions don't have access to the internet so often, that is completely at odds with the kind of democracy we're trying to build, and it's at odds with the kind of modernization process we're undertaking. And just on very quickly statistics, as you mentioned, we have imposed the maximum number of shutdowns for 5 years in a row, and we are well on track to retaining that dubious record for like a 6th year in a row. So I think that's something worth kind of really tightening down through the rules and using the gifts we have from the past, so to speak.
Sumeysh, what do you have to say on this particular thing, where at least in this law, we have the quantum of penalties have also increased, as we are all talking about it. So on the one side, our rights are limited and the penalties are increased to us. What should be the way out?
So purely from the industry perspective, I feel that some of the provisions of the Act might be seen in a positive light, because there is a graded penalty structure. Even though overall penalties have gone up, there is a graded penalty structure. And another thing that we've seen in this Act, that we've also seen in the DPDP Act itself, is the provision of giving a voluntary undertaking, which again is something which can help with compliance and reducing the financial burden. And there is a clearer dispute resolution structure for the industry as well. Like there's a 4-tier dispute resolution structure. There's a clause which says that these offices will be digital by design. So I think from the industry perspective, it does seem to be a slight improvement, but from the user perspective, and especially this obligation on users to furnish correct information and being penalized for that. So I understand where the government is coming from, because they're trying to basically look at impersonation over the phone, frauds over the phone when they're doing that. But I think one of the points that Amrita ma'am mentioned earlier, I would like to echo that with reference to the level of digital literacy that we have in India, with reference to the awareness that we have in India, it seems like this might have create a fear among users as well, right? In terms of telecom services. And the other thing is, in India, we are sort of at an inflection point for our telecom sector. We've had great growth over the last 10-15 years, but if you've been seeing the data for the last sort of 2 years, it's sort of plateaued a bit. And there is a lot of gap remaining in the rural areas and underserved areas. And those are the users which we want those users to start using these services, start coming online. So I feel that from that perspective, penalties on users, obligations to furnish the correct information, that could have been done in a more nuanced manner. Where you maybe penalize more deliberate and malicious intent, but right now the way it's drafted, it's quite broad. So even someone, let's say, entering some information by mistake or due to the lack of awareness of what is to be filled, might be penalized. From the industry perspective, I would say overall it's a bit of a positive, but as a user, I would be a bit worried looking at some of these clauses.
I would now like to two things from all of you one by one. One is about the impact of this law on the emerging technologies. We are talking about 5G, the country would have 5G and a high-speed internet and everything. Now, how does this act helps us in that thing? Like, do you think, and maybe as we are talking about AI and everything, do you think this change in the act help us better? We can begin with Sumeysh, you only. You think it is better for us?
So before I get into the specific answer, at a broad level, when we talk about emerging technologies, so we're talking about first users being able to adopt the technologies and people being able to develop the technologies, right? And this requires like leadership, skill building, culture of innovation. But at a very basic level, when we bring it back to the Telecom Act itself, which is dealing with the carriage layer. So right now, for a lot of these emerging technologies, when you're talking about IoT, 5G, smart devices, they require reliable and consistent internet. And as we move into this era of emerging technologies, the needs for this sort of quality of internet will increase more and more. And this is where I feel right now, if you see, only 2% of the internet connections that we have in India are wireless broadband internet connections. And wireless broadband has certain advantages over wireline broadband has certain advantages over wireless broadband, and you need that infrastructure to be in place as a basic layer for these technologies to come up. And a very interesting thing, so Department of Telecom had done a webinar recently on the Telecom Act, and the session which led to the most discussion was on right of way and infrastructure. Because if you need to enable this, you need to make it easier to create infrastructure. So some of the provisions that are there in the Act itself, when I talk about right of way or infrastructure creation, those I would say I would see them as a positive. Like there's a clear framework now given for right of way. There's a central framework, and some of the people from DoT also spoke in a very positive manner about how they want to make this whole process more streamlined, how they want to make it easier for people to create and disseminate telecom infrastructure. The other aspects that I would say are important are obviously some of the aspects related to spectrum, where there now seems to be an intention to give more flexibility in how to use spectrum, make it more technology neutral. There are clauses for harmonization and refarming of spectrum. Then the focus on cybersecurity also, I feel, is something crucial because I mean, from the user perspective, I should also trust technologies that I'm accessing, and I should feel safe when I'm doing that. Because for one thing, this is something that I've seen a lot with some of my older relatives and all. They have a distrust of the internet because of what they're hearing from their peer group, because of the experiences that they themselves are having. And I think finally, from that perspective, the expansion of the USOF now, renaming it as the Digital Bharat Niti and also talking about it supporting research interventions, as well as the provision of a regulatory sandbox. So I think these are two crucial additions in the Telecom Act, which do show the intent of the government to create a framework where these emerging technologies can come up in a better way.
So, Deepakji, what I want to say is what Sumeysh has mentioned about particularly the whole aspect of not just service in terms of have a better infrastructure, but also it has to be secure. How do you think the change in the law, this new law helps?
So I think as far as security itself is concerned, yes, it's nice to have the word cybersecurity there and having this aspect about the critical telecom infrastructure. But that's something which the government could already sort of notify under the Section 70 of the Information Technology Act. So I do not see that as a very new thing as such. Yes, it comes under the Department of Telecommunications now, and there it was under the IT Act. But under the IT Act, it was already there. And telecommunications is already identified as one of the 6 critical infrastructures for several years in the country now. So I do not see that as a totally new thing. On the security, yes, the verifiability of the consumer, of the customer at the time of KYC, let's say at the time of taking a connection, I'm not talking beyond that. But at the time of connection, yes, that could be something which might be helpful. But beyond that, in terms of security per se, I do not see anything which is substantially very different here compared to what we could have already done. Of course, there was a talk about national cybersecurity strategy, and there was a consultation a few years back about that. And but that's yet to be announced, and we still do have, of course, the national cybersecurity policy, which was announced in July 2013. Now, beyond that, if you see, so what Amrita did mention, yes, so TRA is a regulator for carriage effectively, and not really for the content at this point of time, and that's how things are at this point of time. But when we look at in terms of new emerging technologies, I think one of the other things is when you're looking at internet connectivity itself, one of the promising areas which is coming up is through satellite, for example. Okay. And because of the 2012 judgment of the Supreme Court, a lot of people were thinking about only spectrum being only auctioned. So now in the law, it's clearly mentioned, yes, auction there would be, but there could also be other ways, the administrative allocation of the spectrum also. So that's again something. But as far as spectrum pricing is concerned, we do not see any specific guidance or principles within the law as far as spectrum pricing is concerned, whether it is via auction. Of course, it's clear in terms of auction how things could be designed. But for example, if you're looking at administrative, so let me just share something right now. So if you see, apart from the licenses, apart from the spectrum which is given through auctions, etc., or let's say bundled with any of the licenses for past 30 years or so, if you see other people who are using a wireless link. So for example, somebody has got a link, let's say from one place to another place, and they have to pay certain spectrum charges. Now, if you have that link in Connaught Place in Delhi, or at Naripan Point in Bombay, or for that matter in Jhumri Talaiya, the charges are same. Okay. Now, I do not see any sort of progress or any even directional change in that type of thinking even today. The second thing is in terms of this whole thing, when you are looking at in terms of adjudication, what Sumeysh mentioned, yes, it's a 4-tier structure. So you have adjudicating officers, then there's a appellate committee, and then there's a TDSAT, then Supreme Court. The challenge is going to be that right now people go to TDSAT and then to Supreme Court, and that itself takes at times years, and at times it has taken decade plus. When you have the moment you have 2 more layers below that, my guess is going to be even much longish sort of a journey as far as adjudication is concerned, especially for complex matters. One, because of the adjudicating officers, most likely it won't be their only job. Okay. So for example, if you see TDSAT, this is the only, so it's a specialized tribunal. Of course, they have a lot of caseload. I'm not denying that, but it's a specialized regulator. But if you see the adjudicating officers, if you see the experience from the IT Act, all the IT secretaries of the state had been sort of appointed as the adjudicating officers. So they had to do a lot of stuff in terms of e-governance, IT policies, investment in the IT training, etc. And this was one more thing at their table. Okay. And same way, so my guess is that unless you have adjudicating officers who are doing only this, who can have some expertise, they can develop some expertise, they can devote some time to this type of thing. Otherwise, the moment you have these adjudicating officers and then this appellate committee, again, it's not very clear in terms of how many people are going to be there in terms of committee, and whether it's going to be their full-time thing or it's just one more thing that they have to do. So my guess is that it could have been better to carve out some sort of, let's say, smaller issues to these type of committees or the adjudicating officer, whereas the bigger issues could still go to TDSAT or Supreme Court. But yes, right now we do have the way it is at this point of time.
Question which I want to bring is, with the Telecommunications Act replacing 3 long-standing acts, Bharatiya Nyaya Samhita replacing the Indian Penal Code, and much awaited Digital India Act will replace the Information Technology Act 2000. How does the future of India's regulatory framework looks to you from different perspectives? Like, from the infrastructure establishment we have spoken about, safety of individuals and improvement of legal framework. So I want to talk more about legal framework. How do you see that, Amrita ji and Namrata ji both?
Thank you. I think we are living in exciting times where digital is actually leading. We are doing a lot of things which we were not doing. So definitely to keep up with the pace of technology and its impact, positive and concerning on us, there would be regulations or rehauls needed. So that's what we are seeing with the Digital India Act or discussions on the Broadband Services Bill or even the Digital Competition Act, etc. So that's one part. So we would definitely be seeing changes and laws trying to be rehauled so as to keep up with the times and future times to safeguard user interests, national interests, as well as even business interests. But the thing to be noted is that there needs to be pre-consultation as to what is the exact issue we are trying to address. And there should be a stakeholder discussion with transparency and accountability, because that's very important. If you don't get what you're trying to address and start addressing issues, you may actually create a different beast. So that's one thing. We need to be careful what we do. We need to harmonize between different regulations. For example, as Deepak was mentioning, we have the Telecommunication Act. There are certain things which are being taken care by the IT Act. For example, we are talking about the Broadcasting Service Bill. There are overlaps. Now, we need to kind of reduce the overlaps and harmonize between regulations because they are intertwined in certain ways. If one is regulating something, I don't think we need to have double regulations coming in. So I think it needs to be well thought of. There are coordination between the different ministries and departments, but I think more coordination to come up with rules which are simple. I think rights respecting is important, trying to understand how technologies work. For example, you were mentioning AI. AI is not a 0-1 game. There are a lot of things. You are having different governance structures coming up, frameworks coming up, but what about interoperability? How is it working on gender and race or other issues? For example, we are having talks of deepfake. We're talking about it at this point of time, but how are companies using the data which they are getting, assimilating it, using it, and also using those processed data now, because they are working in a different way. We are just trying to see, okay, this is a spam message or some picture of deepfake, which is disturbing and it is important to address. But how do we govern so that we do not stifle the industry? We bring in more accountability and transparency, and more user rights come in. There should be privacy by design. There should be human rights and when we are building things. And also making people accountable, how the companies are using our data. That's also important. Just as we want companies to ensure that we have transparency in how our data is used, I think we would, since government is also processing a lot of data, we would also want equal transparency from the government as to how it is processing our data. Might be for the best of interest, but I think everywhere we need some amount of accountability. So I would say we will be seeing regulations, but we need to pause, look at it properly, and then run to it rather than rushing into things.
Namrata ji, your point of view, more from the privacy perspective, as Amrita ji has mentioned.
Sure. So on privacy and data protection, the route that India is taking has often been described as the third way approach, where the US has this more laissez-faire free economy kind of approach to privacy. They don't have a central law like the EU does, which is the second approach, which is sort of overly prescriptive and through the GDPR and other mechanisms. So in that sense, globally, people are looking to India as kind of presenting a third way to govern this. So there is that enthusiasm. But I think what tempers that enthusiasm for me a little bit is this shift to an overly principle-based approach where increasingly we are seeing more of quote unquote as may be prescribed in legislation. Now, I understand the need for legislation to be neutral because technology is rapidly evolving. But at the same time, I do think certain safeguards, which also in a principle format, can be built into the legislation itself. So to answer your question, in a nutshell, if I think going forward, we had to look at kind of three things that our regulatory journey should be anchored in. The first would be kind of making frameworks predictable, right? So even under the Telecom Act, we are not yet sure if OTTs fall in. The definition is wide enough, but statements say it won't be. Who has the authority to govern? People don't really know how much of their data where is accessible by whom and to what extent. So it helps people decide what they want to use, what they don't want to use. It helps businesses, so the whole ease of doing business aspect as well. Second, we need to prioritize fundamental rights, and especially privacy and free expression, because I think these two are the kind of umbrella rights from which many other flow. And these two are the common thread to all the legislation that we're seeing develop like over the last year and going forward. And like I said, when we look at the principle-based approach, we can incorporate these principles of necessity, proportionality, data minimization, all these things, even if we don't want to be overly prescriptive in the act. And finally, I would say independent oversight. I think our recent spate of laws and rules, we're seeing less and less of it, even though there is a direct impact on laws. A lot of it is left to executive rulemaking and discretionary power. We need to have independent judicial oversight and a sort of check and balance mechanism to ensure accountability.
Yes, sir.
I just want to mention two things here. One, as Amrita mentioned, in terms of consultation, I think that's very important because, for example, yes, on the Telecom Act, we did have the draft telecom bill, which was in September 2022. But when the final bill, which was introduced, there was no consultation at that point of time, and there were significant changes in between. So obviously, the government has considered a lot of inputs that would have come its way, but then we do not know who said what, etc. And second thing is in terms of the legislative intent itself. So since the parliament itself, so these bills were not really considered by the standing committees, okay? There was not really significant debate within the parliament on these bills. So I think in terms of the legislative intent in the future, as and when we do need to look at that, I think that again is an area where we won't really get much of guidance from legislative intent clarity. Yes, we would know what the government wanted, and let's say there's a statement of objectives, etc. there. But beyond that, there's very little in terms of what really can be seen in terms of the law. And the last is, as you mentioned, that there's a panoply of these different laws and frameworks. So DPDPA, the broadcasting thing, we have National AI Strategy, Responsible AI Framework, Digital India Act. For example, Digital India Act. I mean, all that we know is except the 9 March 2023 presentation, which was made in Bangalore, beyond that, we do not have much stuff really officially. Okay. So unless there's a draft there, then yes, one can talk about, okay, how it is different from the existing IT Act and how it should be done. For example, National Cybersecurity Strategy, again, that's something which is not yet in place. So unless we have all these components, like what fits in where in this whole jigsaw puzzle, and as Amrita mentioned in terms of overlaps, I would say, yes, overlaps are important to be avoided. But another area that we also need to bridge is the gaps. So at times there could also be regulatory gaps between the two. So things might fall through the cracks there. And as we said, yes, overlaps again should be avoided because there could also be people stepping over each other's toes, knowingly or unknowingly or unwittingly. But there should also be a mechanism of some sort of a coordination across different regulators within the sector and beyond. So, for example, how does this whole regulatory system within the digital frame realm work in the fintech? Let's say with the RBI, SEBI, IRDI, etc. How do they work with CCI, etc.? So that mechanism is also needed. Thank you.
So I just want to comment, and I echo everything that everyone else has said about clarity in the laws and all. But just on the privacy aspect, I would like to just share 2 examples, and especially because you mentioned you'll be talking to policymakers and all as well. So I think in terms of how we implement data collection, especially from the state's perspective, there needs to be a cultural shift in terms of how much the state respects people's privacy, right? So if you see on social media, if you see a lot of the chatter in terms of how DigiYatra is being implemented, I mean, technically, if you ask me for my personal opinion, I do find it to be a convenient tool to use, and I have opted to use it. But the way the state is imposing Digi Yatra on people without them being aware of what is being done, that needs a cultural shift where people are allowed to make informed choices. And just another small example, I was talking to someone who works with the One Gujar community in Rajasthan. So what's happening there is that the department has installed camera traps to check tigers and all that. But what they're also now doing is that if any offense or any crime happens in the area and any tribal is seen on the camera trap traveling around that area at that time, they immediately take action against that person as well. Now, this is purpose and scope creep, right? Where you are deploying, where you're collecting data and you're deploying technology for a specific purpose, but then you continue to expand it as convenient. So my limited point is that also in terms of how we look at privacy, there needs to be like a more cultural shift, and we are putting a lot of pressure on big tech and the private players to do that as well. But there needs to be a process where this is something that the government also starts looking at, especially maybe at the lower levels where this is actually implemented.
Just three things as we wrap up. I think based on our discussions, given that a lot of policy students also engage with IGPP, there are two very clear avenues for research that I think we could benefit from. One is the approach to privacy in India. A lot of times we hear that Indians don't care about privacy, and that's not true. It's just about asking the right questions and getting the right answers and examples. Second, just more research on whether internet shutdowns actually achieve any of the stated objectives. I am quite convinced, based on existing research and arguments, that that's not true. Even if it has some benefit, it just cannot be justified in law, but it helps to have that research. And third, finally, what has been said about the consultation process and lawmaking, I want to highlight one particular thing, and that is the need for consultation with civil society, think tanks, and policy experts. I think that consultation is still happening in a disproportionate manner with tech companies and platforms, but not so much with these other stakeholders. And it cannot be a robust, holistic policy without consultation with all these people. Thank you.
Thank you. I think one point I just want each of you to take maybe 30 seconds to 1 minute and give your message to the policymakers. What do you want to convey them about the bill particularly? Not just the bill in the sense, but what do we expect from them?
So I would say that they should be more open to consultations at their own level also. And it's not that any of us knows everything, but I think all of us know together when we work, we will know much better.
So I'll have a more hopeful message. So basically, we've seen this pattern in the late 90s and early 20s where different countries came up with a new Telecom Act. I think US came up with it in 96, Australia in 97 and all. And that led to like a lot of growth in the telecom sector in those countries in terms of revenue, in terms of users. So I hope there is enough consultation in the rulemaking process that allows the operational details of this act to also turbocharge India's digital economy. Like we really need that to move ahead. We are at a great inflection point right now, and I hope that that can be achieved through this act and the rules.
So I would say that now that the bill is there, perhaps, as Sumeysh also mentioned, if there is more leeway when the rules are being made, there is some amount of consultation so that at least the concerns which have been raised can be addressed. And not always raising concerns is criticism. It also means that people want it to improve. We cannot be 100% there, as Deepak mentioned, but we at least should aim to correct the obvious missing points, which you can see. And obviously, it's a continuous process. You would be changing the wheels while the bus is moving. But at least let's have some consultation now when the rules are being framed.
Yeah, plus one to that, and also I think at the core of that message that I think a lot of us would want to share even through the consultation process is that we should employ a people-first approach. How does this impact the end user? Because ultimately that's the person who is going to be impacted by those laws. I mean, we shape our tech and then it shapes us, but we need to look at it the other way around as well.